Christmas Eve 2023. A four-vehicle crash on Interstate 45. One person dead. A firefighter witnesses the whole thing. And the driver? 9 months pregnant, with cocaine and alcohol in her system and unopened beer in her car. But here's the twist. Prosecutors can't charge her with intoxication manslaughter. Why? A legal loophole called causation. Today, we're diving into one of the most controversial BWI cases you'll ever see, where a judge has to decide, how do you punish someone for a death they legally didn't cause?
The only thing that she did wrong at the day and time was drive a vehicle.
With cocaine, alcohol in her system, beer in the car at a .20.
And there's a fatality as a result.
Yes, sir.
Can you please read to me what happened?
Yes, sir. This crash happened back on December 24th of last year. Officers were advised of a four-vehicle crash at 5:37 a.m. on the 6300 block of I-45 South here in Harris County. Investigators observed massive damage on a Chrysler, indicating a head-on impact, massive force damage on a Mitsubishi, indicating a T-bone impact to the driver's side. Officers spoke with the HFD firefighter who was on his way to work and observed the Chrysler strike the Mitsubishi. The Chrysler cut in front of him, causing him to swerve to the right and hit an Amazon truck. He states that this defendant was the driver and sole occupant of the Chrysler, and the driver of the Amazon truck confirms the wheel witness's story and stated that he clipped the Chrysler as he was coming to a stop. The complainant was taken to the hospital where she was pronounced deceased. Officers observed an unopened beer can in the driver's seat of the Chrysler. This defendant stated that she was the driver and that she struck the vehicle. They observed a strong odor of alcohol on her breath, red glassy eyes, and slurred speech. She was transported to the hospital, and a DRE arrived, and she was Mirandized and she waived her rights. She stated that an SUV was stopped in a lane and she tried to swerve to avoid hitting it and then crashed into the other vehicle. She admitted to consuming 4 to 5 12-ounce twisted teas and smoking marijuana.
And alcohol in the car while she's driving?
Yes, sir. SFSTs were done. She scored 6 out of 6 on the HGN. She did not have vertical gaze nystagmus, and officers observed a lack of convergence. They were not able to do the walk and turn and one leg stand due to her injuries of a broken arm and sternum. There was a blood warrant and residual search warrant that were done. And her blood, Your Honor, came back at a .025 for ethanol, and she had, yes, 0.25, yes, sir. And then she had marijuana and cocaine in her system.
And what's the offer that you have worked out?
We worked out an 18-month probation offer with 7 days as a condition, Your Honor.
That's not in the fact that there's a dead body in this case. Why?
Hold on. Let's pause right here. The prosecution just offered 18 months probation with only 7 days in jail for a case with a dead body. Think about that. This woman admitted to drinking 4 to 5 twisted teas, smoking marijuana, had cocaine in her system, an unopened beer in the car, and someone died. The BAC was .025, which is 3 times the legal limit for some perspectives, though we'll hear more about that. She failed sobriety tests, had slurred speech, red glassy eyes, every classic sign of impairment. Yet the offer? 7 days. Why? Because prosecutors have a causation problem. They can't definitively prove her intoxication caused the crash, which means no intoxication manslaughter charge. But here's the question. Does that legal technicality really change the moral weight of what happened?
It's not an intoxication.
It's a causation issue, Judge. We looked at it for an upgrade, is my understanding, because the other vehicle was on the roadway. Legally speaking, there's a causation problem, Judge, so that's why we came to the agreement that we have the families on board.
I'm not sorry, I'm not going to take the You have a dead body here. She has cocaine in the system. She's got booze in the car while she's driving and a dead body. I'm not down with that. No, we're going to have to do something else, but I would be remiss a week in jail where we have a dead body.
Yes, sir.
And to me, just because you're 9 months pregnant doesn't factor anywhere in my mind, Ms. Sanchez. Ma'am, look at me. While you're about to give life, you took someone else's life. I'm sorry. How many lives are now ruined because of this? Not only yours, how about everybody else? Every single day in Harris County, someone is maimed because of the DWI. It's sick that we lead the nation in fatalities. And I don't know why they can't prove causation to charge you with intoxication and manslaughter. But to me, a week is insufficient. It's not enough.
Yes, sir.
So,
We'll go back to the drawing board and get
Go
a
back,
reset, Judge.
but-
Yes, sir.
I'm ready to set this case for trial now. So unless we can work something out today, I'm saying it gets set today.
Yes, sir.
Okay.
All right, thank you, Judge.
Your Honor, I understand that a fatality did occur, but the reason why they weren't able to charge my client with intoxication.
This is what judicial accountability looks like. The judge just rejected the plea deal outright and threatened to set the case for trial immediately unless they come up with something better. His reasoning? That's a powerful statement. He's making it clear that being 9 months pregnant doesn't excuse the severity of what happened. Harris County leads the nation in traffic fatalities, a statistic the judge clearly takes personally. But here's where it gets legally complicated. Without being able to prove causation, the prosecution's hands are tied. They can't charge her with manslaughter, so they're limited to DWI charges.
Manslaughter is because this accident was unavoidable. If you're
Unavoidable?
yes, sir. At the time of this accident, it was unavoidable. What ended up happening is that the deceased party spun out in front of her, and she was just going straight. The only thing that she did wrong at the day and time was drive a vehicle.
With cocaine, alcohol in her system, beer in the car at a .20. Let me ask you something. Have you ever done breath test? Have you ever blown into a breath test machine? Have you ever done those wet labs? You ever done that?
Your Honor. Okay.
I'm serious, really.
Okay.
Have you ever done it?
I'll go one further, Your Honor. Before being a defense attorney, I was a lieutenant with HPD.
Okay.
So I'm above and beyond. I spent 3 years doing accident division. So not only did I investigated these. So my knowledge is probably more superior than anybody in the room. I spent 3 years picking up dead bodies. And that is a true and factual statement I'm making before the court. So yes, sir, I have.
I did, as part of training when I was a defense lawyer, I went to these classes where we took the breath test machines apart, did all kinds of experiments, did these drinking wet labs where you drink and then you blow into the machine. And the one time we did it, we downed a bunch of booze and I blew into the machine and I was lit, right? And I blew a 14 and I was lit, man. And all I did was I blew a 14, right? 0.14. She's at a 0.2.
0.025, Judge. 0.025.
0.02.
Yes, sir.
Okay. I thought you said 0.20.
No, sir, no, it's 0.025 with the cocaine and THC.
No, so she's not 3 times or 4 times over the legal limit, Your Honor.
This exchange just got real. The defense attorney reveals he's a former HPD lieutenant who spent 3 years in the accident division, giving him serious credibility. But then comes a crucial clarification. The judge thought the defendant's BAC was 0.20, which would be over twice the legal limit. But it's actually 0.025, which is under the legal limit of 0.08. This changes everything from a legal standpoint, though she still had cocaine and marijuana in her system. The defense is arguing the deceased vehicle spun out in front of her, making the crash unavoidable regardless of impairment. The judge's personal story about blowing a 0.14 and feeling lit was meant to emphasize how impaired someone would be at 0.2, but now that misunderstanding is cleared up. However, the presence of multiple substances, alcohol, marijuana, and cocaine, still paints a picture of impairment.
We were discussing about Ms. Sanchez. We were discussing when for you to do your jail time. Should we have you do it immediately? to where you have the baby in jail? Is that cruel and unusual punishment? But then again, is a dead body cruel and unusual punishment? You know, what's fair? What's not fair? I don't know. All I know is that you're charged with DWI. There's a dead body, but they just can't prove causation. And that's why you're not charged with manslaughter. But the fact remains is that we have a dead body. How do we reconcile that? You know, you're pregnant now, and I truly hope that you've treated your body well throughout that pregnancy. Because if you haven't, and you've used anything while you're on probation, you're guaranteeing yourself a life of babysitting of a potential baby that will have developmental, potential psychological, physiological issues that you'll have to babysit for the rest of your life, which is punishment in and of itself. It's not fun. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you guys have worked out is 30 days in jail as a condition to probation for 18 months. As part of the probation, does she have any prior DWI staff?
No, Judge.
Any other criminal history?
Juvenile history only, Your Honor, but nothing DWI.
What all were you wanting done on the probation? Correct.
Yes, sir. We are asking for DWI education class, a victim impact panel, guardian interlock, no refusal, no drugs or alcohol, random UAs, 80 hours of community service, and a $300 donation to MAP.
Is this how you understand the conditions, Ms. Sanchez? I will keep you to it strictly. I'm going to monitor you myself. You will report to me here to the court so that I make sure everything gets done well. If you are not in compliance, I will issue a warrant for your arrest. You will be put into jail, and then you'll be facing up to 180 days in jail. If you test positive for alcohol or any kind of drugs, I will put you in a treatment facility in the jail. Do you understand, ma'am? No alcohol, no dope, no driving. You must have what does she have now? Does she have a scram right now? Do we know if she's had any violations while she's been on? I don't think so,
I
right?
haven't
She hasn't
seen
any
any, Judge, no.
Okay.
She has a scram device at this time, Your Honor.
We have to figure out something about as far as the baby situation with the interlock or with the portable device. I will follow the state's agreement here. But like I said, I'm keeping you close to me. From now on, you'll be facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, if possible immigration consequence, you can be deported, excluded from the country, denied naturalization under federal law. Hey, if you can do the repeat offender, do you get the education class? Did you say victim impact panel?
Yes, sir.
How many?
One.
One victim impact panel. You will be required to do a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. Guardian interlock, no drugs, alcohol, random UA. When are you set to deliver, ma'am? What day?
August 28th.
When do you think we should do the time?
If I could request anything, Your Honor, it'd be the beginning of the year, in January 2025, the start of the year. It gives her time to nurse her baby and everything else.
She must get it done within 6 months. Okay. All right, ma'am, how do you plead to the offense, guilty or not guilty? I will find you guilty. We'll send you to this agreement. Good luck to you, ma'am. Please see the clerk.
So here's how this case wrapped up. After initially rejecting a 7-day jail sentence, the judge ultimately accepted a revised plea deal, 30 days in jail as a condition of 18 months probation. That's a significant increase from the original offer, but still leaves many wondering if justice was truly served when someone lost their life. Ms. Sanchez will be under strict supervision, reporting directly to the judge himself. She's required to complete DWI education, attend a victim impact panel, install a guardian interlock device, perform 80 hours of community service, donate $300 to Mothers Against Drunk Driving, and maintain absolute sobriety. No alcohol, no drugs, random drug tests. The judge gave her until 6 months after delivering her baby to serve the jail time, showing some compassion for the newborn while still holding her accountable. This case highlights a frustrating reality in our legal system. Sometimes, even when the circumstances are tragic and the defendant was clearly impaired with multiple substances in their system, technical legal barriers like proving causation can prevent more severe charges. Harris County leads the nation in traffic fatalities, and cases like this demonstrate why. One family lost a loved one on Christmas Eve. Another woman's life is forever changed, and a baby will be born into this complicated situation. If you found this case as thought-provoking and frustrating as we did, make sure to hit that like button. Drop your thoughts in the comments below. Do you think 30 days was enough?